We all need some cheering up, so what better way than 5 minutes of the 5 best upcoming pension cases of the next year. So we're going to take them in the following order: Adams and Carey, then Merchant Navy, then Hughes and the Pension Protection Fund, then the Lloyds transfer out issues, and finally Mitchells and Butler. So let's start with Adams and Carey, Michael. Why should we be interested in that?
So this is about execution-only SIP providers and whether under the FCA conduct of business rules, they have to provide suitability advice on investments, even when they're doing execution-only business. Heard at first instance this summer, and the judge said, no, if the contract's execution-only, that means execution-only, but it's heading to the Court of Appeal next year. And it's going to be a big deal across financial services, not just SIPs, because this is really a case about FCA paternalism. We're expecting the FCA to say that even when the contract's execution only, compliance with the COBS rules means that you have to do some kind of due diligence on the underlying investments.
And how will execution only providers deal with it if they do have to do more than just execute?
Well, it's hard to see how execution only business would really survive, because the kind of fees that they charge at the moment will not pay for the kind of due diligence that the FCA seems to want them to do. So our second case is another Merchant Navy ratings case, yet another round in the saga.
That's right, yet another round. So there are 2 issues in this: whether ill health benefits constitute earned rights, and secondly, another attempt at the point in Lloyds on whether there is a limitation period that restricts the period within which members can bring claims for extra pension where a pension has been underpaid in the past. They're probably more sub-issues in that, but those are the 2 main ones. So the first one really boils down to accrual.
So, I mean, haven't we heard everything we need to hear on accrual already?
Well, previous cases obviously been focusing on past service rights, and I haven't really been looking at how concepts like accrual or earned rights provisos apply to other sorts of benefits like death in service benefits or other benefits which are calculated in whole or in part by reference to prospective service as well as past service. So hopefully it will provide an opportunity to go into some detail on how those accrued right provisos and the like apply to those different sorts of benefits, whether they're outside the net or whether they're the paradigm case of a right that's within the net. So I think that will be interesting to see. Likewise, the limitation issue is an important one. Reminding ourselves of Lloyds, what that said was that a claim for a pension that's been previously underpaid is a claim to recover trust property. So under Section 1 of the Limitation Act, Section 21, then no limitation period applies at all. So there'll be a rerun of that, which will be interesting. So that takes us on to Hughes.
Yes, so this is really fallout from the Hampshire decision in the European Court of Justice, which I know we have you to thank for, Jonathan. There were judicial review proceedings this summer raising lots of issues about entitlement to PPF benefits. But the really explosive one was the judge's finding that the PPF cap is unlawful age discrimination. And this was one of those issues that took the court right into the boundaries of law and politics, the kind of economic and social policy choices that the government had made when deciding ultimately just how generous do you want the PPF lifeboat to be.
So how do you think you resolve that sort of issue then? Interesting as it sounds.
Well, it was difficult because the judge waded straight in and did a kind of proportionality review. PPF are seeking permission to appeal. I think everyone thinks they're going to get it. And the battleground in the Court of Appeal is likely to be not so much whether the judge was right in his findings, but whether he should have been in this territory at all, or whether this is one of those areas where member states get very wide latitude in how they go about implementing EU law. We also have no idea what impact Brexit and the end of the transition period are going to have on this.
Absolutely. Well, that takes us on to the Lloyds transfer out case. So there's already been a day of that, but I understand that the judge has called back the parties for 2 days of further submissions, which is interesting. So this concerns the treatment of members who have transferred out, the court having held in the main Lloyds litigation that the GMP equalisation should be affected.
So what are the issues that you get into with members who have transferred out in particular? Well,
it's always seemed to me there are 3 issues. Firstly, do you get a discharge under the legislation? or does the fact that you have incorrectly calculated the amount of the cash equivalent mean that you don't get a discharge under statute? Secondly, do you get a discharge under the rules? There are obviously some variants of what rules say, although there are also a lot of commonality between different rules in that regard. And thirdly, what effect, if any, does a discharge form that a member signs have? And obviously those will differ in their wording, but nonetheless, the sorts of questions like whether unknown extra benefits are covered by them are important ones. And so it'll be interesting to see what attitude the court takes, if indeed it gets into that sort of question in the Lloyds transfer case. So that's the fourth one. And the fifth is Mitchells and Butler, which is a rectification trial, which I understand is listed for 3 weeks coming on later in the next year.
Surely we've had so many rectification cases, there can't possibly be anything that we don't know about rectification by now.
That's a fair challenge, but I understand this one is dealing with other things, with serial rectification, the question of whether you can rectify a successor deed having already rectified the first deed. And I think IBM does some really useful work in that regard. I think it's with respect to the attitude is right that you should be very willing to rectify successor deeds where there's a knock-on problem that feeds through into later deeds. I think that's sensible and principled. But obviously the second case after IBM will have the opportunity of expanding or considering further IBM. And I think it would be useful to have more detailed guidance about precisely what falls on each side of the line in that regard. So I hope that will come out of that case. So hopefully that's enough by the way of early stocking fillers, but we'd be delighted to discuss any of this more. So if you'd like to chat it through, drop us a line in any way. Thank you very much.
Thank you.